Tammy Baldwin represents the 2nd Congressional District of Wisconsin. She has quickly developed a reputation as a member who is accessible to people of all different ideologies and all different points of view. She's respected throughout the House. She served as an attorney before she came to the Congress, represented clients who have dealt with many of the situations that are the subject of this bill. She's excelled in work ranging from agriculture to energy issues, and we're very, very pleased that she serves also, I believe, in the Energy and Commerce Committee. Is that correct? A committee almost as important as this one. Tell Mr. Dingell that we said that. And we're very pleased that you're with us this morning, and we recognize Representative Baldwin.
Thank you, Chairman Andrews and Ranking Member Klein, and members of the committee for the opportunity to testify today. I am here clearly as a strong supporter of H.R. 2015, the Employment Non Discrimination Act of 2007. Now, as my colleagues know, more than 40 years ago, we enacted the Civil Rights Act of 1964 that banned employment discrimination in certain circumstances. We did so based on a clear record demonstrating that some employers were judging employees by factors wholly unrelated to their work performance, their skills, and their abilities. We found as a nation that when employer judgments were based upon race, color, sex, or national origin, these discriminatory decisions should be unlawful. Today, we can point to a clear record demonstrating further employment discrimination based on sexual orientation and gender identity. And I think it's high time that we as a nation declare this sort of discrimination unlawful as well. 25 years ago, my own state of Wisconsin was the first state in the nation to add sexual orientation to its anti-discrimination statutes. At that time, and we're talking about 1982, only 41 municipalities in this country and 8 counties offered limited protections against discrimination based on sexual orientation. Wisconsin's efforts to pass the nation's first sexual orientation anti-discrimination statute were supported by a broad bipartisan coalition, including members of the clergy, religious denominations, medical and professional groups. The measure was signed into law by a Republican governor, Lee Sherman Dreyfus, and he signed the bill based on his decision, his belief that the success of municipal ordinances providing similar protections spoke for the need for a statewide prohibition. Now, prior to my election to the Wisconsin State Legislature back in 1992, I practiced law at a small general practice law firm in Madison. And on occasion, I represented clients in employment discrimination cases. Through this work, I was able to see firsthand the importance of Wisconsin's landmark anti-discrimination statute and the positive effect that it had on our state. I represented a number of clients who were fired from their jobs because of their sexual orientation. And Wisconsin's statute was vital in affording them the employment protection that I think all Americans deserve. I was struck during my time as a practicing attorney by the depth of the emotional and financial devastation and consequences of employment discrimination. My clients were frequently fearful and ashamed. They were talented and hard workers, and they had had their livelihood taken away for reasons wholly unrelated to their talents, their drive, their loyalty, their commitment, and their skills. But the fact that Wisconsin had a law that said that this type of discrimination was wrong gave them hope and helped them find the courage they needed to publicly confront the injustice that they had experienced. Since Wisconsin passed its statute 25 years ago, 18 additional states and the District of Columbia have passed similar protective measures. And we have a chance to now set a higher standard for our nation by passing 2015. As my colleagues know, the Employment Non Discrimination Act, or ENDA, will provide basic protections against workplace discrimination on the basis of sexual orientation and gender identity. ENDA does not create special rights. It simply affords to all Americans basic employment protection from discrimination based on irrational prejudice. I'd like to take a moment to focus on the protections in ENDA that prohibit workplace discrimination on the basis of gender identity, because I found that there's a great deal of questions and confusion about this term. Gender identity is a person's internal sense of his or her gender. In the vast majority of our population, an individual's gender identity and his or her birth sex match. But for a small minority of people, gender identity and birth sex conflict. Because an individual was born one sex and presents to the world as another, or in a way other than people think is consistent with how a man or woman should present themselves, he or she can face many forms of discrimination, from physical violence to employment discrimination. ENDA contains language that makes it clear that an employer may establish and enforce reasonable and otherwise lawful dress and grooming standards for employees. But it also provides assurances that aspects of a person's gender identity and gender expression cannot be the basis for workplace discrimination. ENDA ensures that an employer cannot fire an employee solely because she is a woman with a masculine walk or a man with an effeminate voice. In conclusion, I want to underscore that the purpose of ENDA is to ensure that hardworking Americans cannot be denied job opportunities, fired, or otherwise discriminated against just because of their sexual orientation or gender identity. There is nothing more American than ensuring that people should have equal job opportunities. And I want to thank Congressman Frank for his leadership on the issue, also acknowledging Congresswoman Price and Congressman Shays for their commitment on this issue. And again, I sincerely appreciate the opportunity to testify you before on this important matter today. Thank you.